are live.
All right, we're back to the House Judiciary Committee this Friday afternoon, March 13th, and to brief recess. So we have a motion on the floor. This is just a straw poll. The motion is to approve amendment draft number 3.1 to H606. All those in favor, raise your hand or say aye.
Okay.
Coach, or aye.
Aye.
So there's six, and all those opposed, raise your hand. Okay, 6-5. I will now take a motion.
The amendment was the piece we just put back in this morning by request, right?
Yes, yeah, well, the whole thing's an amendment.
Oh, okay.
Yeah, the whole
Gotcha,
thing is
gotcha.
a
Okay, I
strike
thought you were
all.
talking
Strike
about
amendment to the
okay.
amendment. Right. Yeah, the whole
Gotcha.
thing. We'll take a motion that we report H606.
Are we having any
favorable with
discussion
amendment.
for
Yeah, absolutely, after the motion.
after the motion?
So moved.
Second. Open it for discussion. Zach?
Oh, yeah. I mean, I guess I'll start. I don't think it's probably a secret. It certainly isn't a secret to any of the committee members or the people in the room of what my concerns are with this bill. And I guess I want to first thank the vice chair for his leadership throughout this process. And he knows certainly my frustrations with the bill as currently written. Thank you, Nate. I appreciate the chair's willingness to add the petition back in. I also appreciate the chair allowing additional testimony. But my concerns do remain with the bill on face value of the constitutionality concerns around Section 3. And I hope to work with our colleagues in the Senate Judiciary Committee on that. And I guess part of me, Chair, wants to give voice to maybe some of the frustrations that a lot of members of this committee had at the end of last year, that we didn't feel heard, we didn't feel seen, we didn't feel that our concerns were being appreciated. There was no willingness to compromise, because in the conversation that we had last night, I mean, I made a very, I think, strong overture that if Section 3 was removed from the bill, that you would have gotten far more support than you're going to get today. And I know that you personally take great pride in running your committee in a very strong manner, reporting bills out as close to unanimously as you possibly can get them. I just think it is a missed opportunity and a shame that we can't get this closer to an 11-0-0 vote because of a lack of willingness to compromise on one section out of 3. And I will say that I am very appreciative of you having the NRA, the National Rifle Association in here, as well as the Federation and Gun Owners of Vermont. And I appreciate too, you including language directly drafted by the NRA in the bill. So I do think that is a great hallmark of compromise, to have the NRA's input considered, and the committee going to be voting, some members of the committee voting in favor of the NRA's language when they vote in the affirmative for this bill. That being said, I just can't support this with Section 3 in. I wish that we had more time. I wish that we had been more cautious and careful in the crafting of this. And with that, I will not be supporting the bill.
Yeah, Barbara. Well, actually, before Barbara, just a couple comments. So I appreciate it. I appreciate the questions that you've raised, the issues that you've raised that I think have made this bill, in fact, better. I think the idea of compromise is, yes, I always am trying to find compromise, but there sometimes are a point where you can't go any further. And I think that Section 3 is a critical component, in fact, probably the most important component of this bill that can do the most. And I definitely compromised a lot with Representative Donahue when she saw this language and she made suggestions, and I had to work with Eric to put that into the amendment that I proposed. I put in the petition, which I guess in and of itself is a good idea. But I mean, so compromise doesn't mean that you're going to get everything. That means strike that section, but I really think it's very important. But I appreciate that we have been working together on this, and I definitely, outside of committee or even in committee, discussions that happened before this bill was ever introduced, and then the input I received from many people out there, including from Chris Bradley as well. Part of the compromise was I took out Section 5, and in the testimony the other day related to machine guns and rapid fire devices as a compromise again. And with all these compromises, I'm still not expecting any Republican, and I understand politically why you won't vote for this, and it's fine with me. But I just want it to be understood that despite the fact I wasn't going to get any additional votes from this, I moved this bill a lot, and really in favor of folks who want to protect gun rights, which I do too. So in any event, I just with that, but I do really appreciate how you've been working with me on trying to actually make this a better bill, even though you can't ultimately support that. And that happens. It happens all the, not now, actually not that often.
Well, I
in
think
this committee. So.
a Latin phrase comes to mind, and it's Vox Plumidis in Deserto, and it's the lone voice crying out in the wilderness. And I think that is a feeling that a lot of us share in this room and in this building, that we are screaming out into the wilderness, and it just continues to fall on deaf ears. And again, Martin, I appreciate that you worked with the representative Donahue from Northfield on this, but you're also sitting, across the table from 5 Republican counterparts as well. And it doesn't feel like our input was really heard in this. And I grant you, the petition was already in the bill, it was removed, and then it was added back in. So I understand that there's been give and take, and the Article compromise is that both parties are going to walk away not entirely satisfied, but it seems here that one party seems extremely satisfied and the other is still crying out into the wilderness.
I think a couple things. I think we're far from satisfied. There's a lot of disappointment on this side of people who want this as strong as possible. And there's a huge difference between listening and being heard and then I'm going to agree with everything you say. And to say that I have not, and that this committee has not listened to all the various different views on this bill, including from all the members in here, is a disservice. And that I reject that part. So anyway, over to Barbara as far as discussion.
So I guess this wasn't going to be part of what I originally said, but I think all of us often feel like our voice isn't heard, because if Martin took every one of our individual requests, we'd probably jump out the window before. I mean, you couldn't please us all. But I lobbied for things that never made the draft to begin with, including things that were really important to my constituents, the guns and bars, safe storage. Those didn't make it. When Section 5 came out, I was incredibly disappointed. However, I am supporting this bill. And I think Section 3 is what we heard from so many people, could make a big difference. And I like that, again, we're not just putting in things that don't necessarily yield anything. Like, we shouldn't be taking things that feel like we're taking away if it's not going to make us safer. And I do feel like this will make a difference. And I remain disappointed, and I will continue to be a lone voice on many other things too. But I think I guess I just want to say, as somebody in the Democrat side, it often feels frustrating as well.
Yeah.
I'll say, not as a Democrat or a Republican, but just as a person who lives in Vermont and wants everyone in our state to be as safe as possible. This is a public safety bill. It's a public safety bill that addresses pretty specific firearms related public safety issues. That's what it is. And I feel good about voting for a public safety bill. I feel disappointed about the things that aren't in here. And I think all we've done on this bill is take things out. Since, how rare is it that something is introduced and we don't even talk about the as introduced version? We just go to the cut down version. I can't recall that happening in my time. And that was in response to concerns that were raised. So at the very start, something I really wanted, gun industry accountability, was removed. It happens. It happens. And I am still proud to vote for this bill as a public safety measure. And just so that we're all working with the same definition of compromise, the dictionary says an agreement or a settlement of a dispute that is reached by each side making concessions. I think that the process undertaken with this bill very clearly meets the definition of compromise.
Anything else? Yeah.
Yeah, very briefly, one thing that just hasn't been mentioned, but I think is really good in this bill that I'm excited to vote for is that we are aligning some Vermont laws with federal law, which to me is very important, that there's consistency when it comes to regulation, and this bill is trying to do that. And in some ways is more narrowly focused than federal law is, which shows real intention in how this was drafted. So I'm going to vote in favor of it, and I think that my constituents will appreciate that vote. And I appreciate all the work that was done on both sides to get the bill to where it's at now.
Anything else?
I wasn't gonna say anything, I'll just say it real quick, that it's not done. I mean, we know it's not done. This is only half the process right now, and anybody who still has issues with the bill, whether it may be the gun owners or it may be the sportsmen or whoever, there's still potentially some work to be done on it in the other bodies. Yeah. A lot of time.
Said no.
I guess one thing to pick up on what Ian said, I really do also appreciate that we are able to take these public safety measures through on well-trod constitutional ground. That by largely mimicking tested federal statutes, we give ourselves, an advantage, a leg up on constitutionally. And anytime we can do that, I think it's well worth doing that.
All right, the clerk can call the roll.
Arsenal,
Yes.
Dolan,
Yes.
Goodell,
Yes.
LaPlante, no. Harvey,
No.
Malloy,
No.
Oliver,
No.
Rachelson,
Yes.
Chrissy.
You're on mute.
You're muted, coach.
Yes.
Verdict.
No.
Well,
Yes. And Angela has agreed to report the bill, so she will get that over to
Yeah, thanks.
clerks. So thank you, everybody. That's been an interesting process. So we're going to move to the miscellaneous bill. Everybody should have it on your. Now, the question is, what does the committee desire now? So my understanding is the language been added to this bill. This is 311. What's the date today?
13.
The language that was from H5, whatever that, what the hell?
629?
629. Is that in here somewhere? Hiding somewhere?
Yes.
Could you just point to that real quick?
That is section 5, which starts on the very bottom of page 8,
Okay, all right, so just.
on the top of page 9.
All right, that's fair. Oh, no one was here for the miscellaneous. Yeah, I guess.
Are we only looking at what's been added?
It's up to folks. I mean, if this was,
Has anything been taken out?
nothing's been taken out. The only two things is what Eric's going to talk about. And the thing that's been added, we went over separately. We had a bill, we had testimony on 8629 and decided that to not have so many bills going over to the Senate, that it was appropriate for in here. So we had separate testimony. We put that bill in here. So that's an addition. And then there's an effective date change, which Eric can explain. Those are the only two things, my understanding, Eric, since what we reviewed.
Yes, there's one cross-reference, two cross-references that were wrong.
Okay, so if you could go over.
That I changed.
don't,
Yes. So those from the beginning. Okay, here we go. So as I mentioned, I noticed, you may recall that one of the things that went on in this bill was that the profits from crime subchapter of current law was moved from the Victims' Compensation Board statutes to the Attorney General statutes. So during the course of that being moved, a couple of internal cross-references I neglected to update because they were no longer correct. And that's on page 2, line 14, and page 3, line 12. So those are just technical cross-reference changes that were corrected. So that's one change. I looped them, grouped them together as one change.
Yeah, I had noticed that actually. But just kidding.
Yeah. The,
In your careful review.
to be honest, I wasn't gonna mention it, because if there wasn't gonna be any other changes, I was like, let's fix that in the sign. Since you're changing other things anyway, I might as well do it.
Impossible.
Right. So the second one, as the chair mentioned, it starts, it says page 8 through page 10.
At the bottom of page 3, bottom of.
Yeah, that's just the title, but that's the substance of it. And basically, this was a bill, H629, which you took testimony on last week. Michelle's bill, she did the walkthrough. I think you had a number of people from the Bar Association Family Law section, and the essence of it is that generally speaking, when you're an action to renew a judgment has an 8-year statute of limitations, but the idea here is in response to a Supreme Court decision to have particular rules for how to file a motion for renewal and a family court action, particular types of family court action that might be related to money or property, that sort of thing. So it's a kind of a carve out for the general 8-year statute of limitations for renewal of judgments, and with some specific processes for family division judgments. I think you probably
We heard.
about it than I did.
Right.
I wasn't here that day.
And I think the key was that there's a lot of language, but the concept is fairly straightforward and there was no controversy on it, so. And I guess you go to the last is
Yeah, just since we're on page 9 anyway, if you look at page 8, because that's what the last thing is going to refer to. Page 8, which is section 4, which starts over on the bottom of page 7. So this section is unchanged, but I'm just pointing it out because it's related to the change in the effective date. This section has to do with the dissemination of criminal court records. Remember, the change here is that right now under current law, their access via the internet for criminal case records is prohibited. But the change is that for criminal case records, that won't be prohibited anymore. But this is page 8, lines 9 to 10. The procedures for how access via the internet via criminal case records is going to be set forth in rules promulgated by the court. And what Judge Zone pointed out was that that's a time-consuming process to have rules proposed and promulgated, and so that the effective date for that section would be helpful to have it be different. So that is section 4 of the bill. So then if you turn to page 29, you'll see the effective date. A few words have been added. It says this act shall take effect on passage, except that section 4, the one we just looked at regarding the rules, shall take effect on July 1st, 2026. So that's got a little bit longer of an effect.
That's enough, he said.
That's what he asked for. Yep.
All right, so I guess the question, I assume people don't want to go back over it.
I'm gonna second myself. No, I'm not. I'm not.
So I assume that we don't need to go over each section. I guess the question I would have with people is. Good job. I mean, I'm missing a few people. The question is whether there are any problems with this or if we're ready to. Yes.
So I don't know if I assume many of us got these emails today from
I don't have looked.
about adding a section, which
No sections can be added.
so I'm assuming
See that?
children's advocacy organizations
Yeah, I'd love to.
Oh,
Look that.
so
at the Senate side, like.
There's a
so there's a couple things. Yeah, I had received an email and I neglected to get back to the person because I looked at it and it's more of an education. Senate comment and their legislative council. I don't know what if anything, if they're gonna put it in their miscellaneous bill or so you can, and I meant to get back to the person who reached out to me on that, that this wasn't really appropriate for, and I talked to Eric about this. We agreed it wasn't really appropriate for this miscellaneous bill. Right,
Thank you.
Definitely get back to them yeah, and again, I apologize.
No, that's okay. I just
There's
wanted to.
Commissioner Black is a
I
person.
started hearing from multiple people.
Yeah, but she's
today.
the one originally, and I just dropped the ball and telling her what I've done with that. That's all.
Okay, thank you.
Beth is gonna check into whether or not it might go into
I think
miscellaneous.
Beth was gonna do it, but I should have let the person was advocating for it.
And they may be watching.
Yeah, so, well, I sure would like to vote to take care of this.
Do you want a motion?
Well. Yeah,
I mean, a moment ago, the people that are out of the room were the people that were saying, let's get going. Right? Like it feels like,
well, this will happen.
you know, I know,
Yeah,
but like we should be consistent.
okay, all right. So am I gonna, is Tom
Yeah, he's right there, I think.
and where did Zach?
He's right there.
They're both right there. Okay, all right, let's wait.
I don't think it's start the process.
But
Well, I want people here that there's emotion on there. I mean, we can, I'm in a hurry, not really in a hurry. We're doing fine.
You've already killed my afternoon, so.
Jesus, I mean, that's not a hurry, let's go.
I think that was the roll call.
That also,
Oh, my God.
And all the questions we had on third reading, that's
I
like.
know. You love this.
I did love it. I mean, I'm delighted to see the floor.
Where's that?
Well, I just,
Check.
should we just?
I didn't know I texted
You did.
everybody, but you want to text them directly.
Yeah.
So since I have a couple more people in here, Tom, did you have any objections to any of the parts? I wasn't gonna look, I mean, in the past, when we've done this, I'll go through every section and get everybody agreement on, but this one
No.
seems so innocuous that. I don't wanna do that.
No.
We didn't do that today, but we've done it through the course of building the bill. So.
Yeah, I haven't heard any objections.
Window opens now, you know.
In the past, I-
You're hot.
Oh, what's the
Oh, oh, you're live. Jeez.
I got that correct. Let's go.
In fact, when we had this, there was one person that I took out, because there were a couple.
Yeah.
I didn't have any issue.
and you can.
Do we need to hear anything more on the joint tenancy?
Can you summarize, are you reporting that part?
I will be able to at some point.
When do we,
What's that?
when do they go to the floor?
It's on a notice for 2 days. I don't think there's any money in this.
I was noticed for 2 days.
Yeah, because it's a committee bill.
Oh.
I don't think that there's any money on it, but it seems often I think that
They get sent
and
anyway.
they find some money.
Like someone's gonna breathe on it and we have to pay for that.
Creditors claim, yeah, I mean, so. Oh, no, I take that back. I did find ways and means here. There is a ways and means.
Ways and means.
So then you, then me.
There is, yeah, it has to go to ways and means.
Right?
There was a change that there would be a change in, it was one of the,
Cut that out.
it's one of the diversion things that is gonna lead to less, fewer. It's the reinstatement. Trying to find it.
Right, the fees to reinstate your
The fees to
license.
reinstate license,
Right.
because it's automatic, it'll be automatically reinstated, so there's loss of, it affects revenues of the state, so it has.
All right, in that case I will.
There were fees
It
involved.
could be, 1001. I mean, I'm not gonna hold up, I've, a couple of people,
You didn't see him.
Can we leave it open a little bit?
yeah, because we need to get to the youthful offender one, because there's some language changes, we need to look at that. I will take a motion, wait, let me think, what's the motion for a committee bill? I should have it right in front of me, maybe.
We have to hold hands and sing a song.
Committee report then.
Well, I was gonna say, the other one is good too. That's a fun bill too.
You have another committee report recommended amendments in addition, right? It does, I guess I just should say, I'll take a motion that we report committee bill draft 2.1, the draft request is 26-0161 favorably.
I move that we admit, what he said, so good.
Second, even though we may not need.
Second.
Also known as the miscellaneous judiciary,
Also known as the miscellaneous judiciary bill, thank you very much.
AKA
Any discussion? Not seeing any, the clerk, please call. Yes.
I know, he's.
So we wait for one member, but we're not waiting for another?
We did.
I think we've, a couple people have texted, and we're voting. I mean,
You
I
can
can
leave it open, right?
No, you can't leave vote.
No.
Until
No.
you do the other thing.
Happy to call that number as well.
So this. Yeah. I mean, I feel a certain level of responsibility here, but we do
Right.
something one way and not in that, I'm not comfortable.
I don't see it, but I can.
I mean, so if somebody leaves and is unavailable, am I gonna pull up on the last day before crossover, doing our business? I mean, I can have that motion withdrawn and we can, but I don't know, am I gonna lose other people?
Well,
And
Martin, I'm not trying to start anything, but
No, no,
I
no,
mean,
no.
if we could have got hold of coach on that last vote, we would have waited.
You step out and make a call. It'd be the same person making.
The only difference was just that coach was on here.
Yeah,
And
and
it
Well,
was
he
like-
was in the room.
he was having, well, coach was having, there were technical difficulties going on right there.
Yeah,
as
well, I'm
opposed to
having
the left.
technical thing.
And
So Kim, all right, so we will.
I just want to know what's right and what's wrong. I'm the clerk. I feel I have a certain responsibility and I'm just.
So I can have the motion withdrawn for now?
No,
What do you want?
I just have an opinion that, yes, we did wait for coach. Probably 30 seconds. His picture was up there, it went off, his camera was shut off and he came right back on. When asked whether he was asked to or not, I don't know if anybody got hold of him to come back, but he came right back. And I don't think this isn't such a controversial bill that.
Ah.
No, we're-
Speak of the devil and he shall appear.
Yes, I know.
right. So like, yeah, no, that's fine. So we're good.
And
So,
Do I need to renew the motion?
so this is a motion for passing the miscellaneous petition.
All right, no changes were made while I was there.
No changes.
I wouldn't put anything past anyone.
No, thank you. guys.
Arsenal,
Yes,
Dolan,
yes,
you know,
Yes.
both saying yes. Harvey,
Yes.
Malloy,
yes.
Oliver.
Yeah.
Richardson,
yes,
Christie.
Yes.
Christie,
Yes.
verdict,
Yes.
well,
Yes. And Barbara's agreed to head this up, but it will be one where we pass. I bet you're gonna want to.
Well, I was just gonna say, I know I missed
Of it.
discussion, but I just want to thank the chairperson from a very personal standpoint and the committee for their support, because there was a section of this bill that was deeply personal to me and my family. And it means a lot to me on a very personal level. So I just want to say thank you to everyone.
is that a section you want to report?
I would very much like to report, so that's section 8.
All the sections have the sections.
Oh, they may have changed, but
The stocking.
the stocking section, yeah. I just want to say thank you
Yeah,
very
absolutely.
much.
It's definitely fit into.
so we have two that are,
So no, it's just Barbara because she's gonna be the lead.
I will let you know.
And sign parts, yeah.
Thank you, Eric.
There were fewer parts.
Yeah, this is very serendipitous. Well done.
We're moving to H642, which probably of all the bills today, despite the fun that we had with the gun bill, has kind of the most moving or the changes, based on the testimony that we had yesterday, I guess it was. And I,
Thank you.
so Eric can go over the changes and I can go over, I don't think everybody was in here when we were kind of trying to give the directive or what we should do with the next version of this. But trying to simplify this as much as possible and do as much as we can in the bill, given the testimony. You know, I went through, whoever was here, and it's online, obviously, that this is what I'm going to suggest to Eric, or that this is what I think we should suggest, and everybody in the room at the time was fine that these were the things I should suggest for this version. So I just wanted to let you know where this came from, and we can discuss the individual changes when Eric goes over. So Eric, over to you.
Yes, thank you. moving along now to H642, activating to youthful offender proceedings. I'm hopeful that what everyone has in front of you now is a version that shows some highlights. You'd see it right on page 1, the first highlight. And this is a version that will show the highlights between draft 2.1 and draft 1.1. And as the chair indicated, section 1 is actually struck in its entirety. It's just, I didn't use all that yellow to show you this, but you can see that originally it contained a provision about acknowledgement of harm by the youth. So it was, sort of goes into this finding that the court has to make about public safety, whether or not someone is going to be granted youthful offender status, turns in the first instance on whether or not public safety would be protected, and the court has to make a finding. Original proposal of the bill had been to add to the list of factors that the court has to consider when it makes that public safety finding, whether or not the youth has acknowledged harm caused by their conduct. Proposal in the new version of the amendment in front of you now is to just strike that section entirely, so we just go back to existing law.
So, and I'll just explain the testimony, and I didn't hear all the testimony on that, but it seemed like a very problematic section. We tried to fix it with some language regarding the youthful offender that would be used against them for impeachment. But we heard from, well, at least that when I was here, I didn't hear the earlier testimony like that. This was probably unworkable. It wasn't like you weren't going to get the acknowledging.
And
So
maybe
that's why
unconstitutional.
I suggested we strike that.
And maybe unconstitutional is what.
Oh,
Okay, it was Kate Hayes.
Kate Hayes, right?
Yeah,
Said
Judge
there
Hayes.
might be some
Judge Hayes.
Judge,
Judge Hayes.
current Judge Hayes, right?
Yeah.
Retired judge.
I feel like you always call him Judge.
Yeah, I'm just trying to remember. Job manager. Anyway, yes, it was a constitutional issue that was raised.
Right.
With the changes we have and Kim being in here, I don't know if she prepared, maybe get a 10,000-foot view of.
Yeah, let's have Eric go through the rest of the changes.
Okay.
And I did ask him to be here in case there were questions or wanted to weigh in.
Okay.
Yeah.
Yeah, no, just looking for 10,000-foot view. Yeah.
So that would be change 1, strike section 1 in its entirety. So
Can I
section,
just butt in real quick?
please do.
So I got the highlighted here. I just want to make sure we're talking about 3/12 of 26, right? 4:34 PM.
Yeah,
Thank you.
you got it. So that section is proposed to come out of the bill entirely. So section 2, which starts on page 4, which would then become section 1 of the bill. The first change was accepted. So in this section, you remember, this has to do with the hearing that the court has to have. If there's a motion filed to revoke the youthful offender status because of a probation violation. So the proposal, you recall, was over on page 5, is to allow the family division. Because remember, that under existing law, the youthful offender jurisdiction in the family division only lasts till age 22. So that can create problems with a probation violation comes close to the time of the youth's 22nd birthday, for example. And what is the court going to do then if they may lose jurisdiction over the youth before they can resolve the revocation issue? So the idea of the language that you see on page 5 with a slight change, which is just say, all right, instead of a modification, because this is really a revocation issue, if the person the youth is subject to a revocation motion because of a probation violation, it allows the family division to extend jurisdiction past the youth's 22nd birthday. That's the gist of that. Just one word change. Go ahead.
Yeah, and I didn't bring it up yesterday, but I had a concern about whether or not DCF would have the resources to handle this. And from what I heard yesterday, that I don't think there's going to be any issue as far as them having ability to handle any, even if it's not even really extra work. Right. Just a longer time period.
But can I just clarify one thing that
Yeah,
Eric already
right.
said? So Eric, I just want to make sure I understand, even though you only highlighted the title, you're saying those pages are going away?
Yes. I only highlighted the title to kind of remind us
Okay,
what that means is, because the only change in this section that was made in the bill, which is on page 2, line 16 to 20, that change is being proposed. The proposal is don't make that change anymore. So that means there's no changes that's going to be made to this section of law. So the whole section of the bill will be struck.
but we're not striking, I mean, it's not repealing that section of the law.
Correct.
That section of the law is still on the books.
It is, and it will remain
Yes,
on.
so I just want to make sure that's super clear to everyone that, because
A quick point about that though. There is one other change, but I'm assuming it's a technical change, so is it?
I know the capitalization
Yes.
requirement issue, I will not.
You just don't do that, right? Okay.
We can do that in the stat rep process.
Okay.
Yes. Back on page 5, and I missed some of the testimony on this, so if it was answered, I apologize. So I'll keep it very brief. Revocation of youthful offender status is pending pursuant to the section. That's lines 5 and 6 on page 5. Then family division may extend its jurisdiction beyond the youth's 22nd birthday. Does the pending motion for revocation have to be pending the full time for the jurisdiction to be extended?
No, I think that the operative moment is going to be when the family division makes the decision to extend. So that's at that moment that it has.
So we've got the pending motion for
Yeah.
revocation. We
Yeah.
then get the hearing on the revocation. Now there's an opportunity. Okay, are we going to extend this out?
Exactly.
And that's how it's being. Okay,
Right.
that makes sense.
Yep.
Great.
Yep.
Thank you.
another question. So modification or revocation still exists and is referenced, but it no longer exists for subsection 2.
Yeah, it's not that it doesn't exist, but I think that's what you're getting, is that for purposes of subdivision 2, which is a particular option of the family division, when a revocation motion is filed, the family division's going to have this option to say, well, it looks like for whatever reason, I'm going to suggest that it's probably going to be in a case where the youth is particularly close to age 22, that they can extend.
But not for significant, I mean, it's interesting because there could be significant modification.
Oh, you mean why is modification being struck?
Yeah.
I think it's just a matter of if it's a motion for revocation is when the ability of the family division is going to kick in. So if you're the state's attorney or somebody and you want to have the family division have that option, probably would want to file a motion for revocation instead of a motion for modification, because they could always decide themselves, I guess, whether they're going to file one way or the other.
So while we're on this issue, if Kim could identify herself for the record and weigh in on that, because I can see that you want to.
Yes, thank you. Kim McManus, Department of State's Attorneys and Sheriffs. Yesterday, Judge Sunday pointed out that there is a mechanism to motion to modify,
Right.
and we do that often
Yes.
on juvenile probation.
Okay.
But if we're now
Got
extending
it.
jurisdiction, we wouldn't modify at that point. It would just be either discharge or revocation. After 22, we wouldn't be modifying their probation because.
So it might not be, because I was thinking like, if somebody is in substance abuse treatment and it seemed clear that they might continue to need that or something, ask that, like, no, that wouldn't,
Well, only because
of the age.
this section is only about extending.
Right, but we wouldn't
jurisdiction.
extend it so that somebody keeps having access to a service
Mm,
that they might not.
That would be that. Is
Okay,
intended
all right.
to.
Because there'd be the issue of when does the
The
jurisdiction end?
It's the whole reason we.
It's not past 22.
Yeah.
As long as Alicia's, we're all apparently. Look.
All right, thank you.
All right. Any
All right.
other questions on that bit?
On the same page for a moment, just because this will transition us into the next change. You look on still on page 5, lines 13 to 14. So they're having this hearing, right? When there's a motion to either modify or revoke the youth's probation. There's this list in statute of factors that the court, there's a list of options that the court has if they find that the youth has violated. So they can, they can maintain the youth status, change the conditions of probation. They can revoke the youthful offender status, transfer the case back to the criminal division, et cetera. There are those list of options. So I need to turn over on to page 6. this next subdivision, because subdivision 2 starts on line 6. This is the list of factors that the court will have to consider when it's making that determination. In other words, what am I going to do? Am I going to keep the person on youthful offender status with some modified conditions, or am I going to revoke YO status, send it back to the criminal division? When making that decision, you've got 3 factors, A, B, and C, page 6, that the court has to consider. And there's just some technical change to B and C, really, instead of saying the youth is amenable to treatment, whether the youth continues to be amenable, which makes sense, because at that point, there already was a finding when they became a youthful offender in the first place that they were amenable to treatment, but now they violated. So it's really the question is, are they still amenable to treatment after that? Similar idea. Actually, remember the discussion of whether it makes sense to say sufficient or insufficient. And I think the conclusion of the committee was whether there are sufficient services in both departments to provide for the youth. And then a separate issue is subsection D, which is, you remember what happens, okay, if somebody's filed this motion for revocation or modification, modification, and the youth doesn't show up. That's the circumstance you're talking about here, subsection D. And the previous version had specifically said, well, in that case, the court shall summon the youth to appear before it or issue an order for their apprehension. I think after testimony, the committee heard that there's an existing statutory process that you could reference that may do the same thing. So what the proposal is, it changes it to may, first of all, line 13, but not a requirement that the court do this, that there's a failure to appear, but the court may, and then down to line 16, issue an order pursuant to subsection 5108C for an officer to pick up the youth and bring the youth to court. So that's just mimics the language in that section, which I'll read to you, which is also in the juvenile probation statute, which says, gives the court some authority. And in that case, the court has authority to issue an order for an officer to pick up the child and bring the child to court. So it's just taking that same language and saying, the court can do that too, specifically in this situation, if the youth has not shown up at the probation hearing. So that's that piece. And then the very last thing is on page 9, just the effective date from on passage is July 1st.
I just said, I think I had to see. Okay. Any other for Eric? Otherwise, Kim, why don't you join us and weigh in on this so far? Because I barely said one. Yes. I had
And you guys are.
It works. Thank you for being here.
Kim McManus, Department of State's Attorneys and Sheriffs. I'm only going to speak to the change on page 6 as far as the cross reference to subsection 5108C. This, and I fully appreciate Judge Zoning saying very clearly that his reading of 50108 is that judges can issue a warrant in family division. That was very clear. It's our position that not all judges interpret 5018 to give them that ability. And this specifically is giving the ability to pick up the youth and bring them to court, which we already have that judges are already ordering that. And we had advocated for the ability to issue an arrest warrant be explicit in this section. As amended, I think we're going to run into the same issue of having differing opinions moving forward. And we can see how it goes. It could be an educational issue amongst the judiciary, and maybe that resolves it with this language. But I think some judges will still read that they can only issue a pickup order for youthful offenders. And as we mentioned yesterday, that does not help us with out-of-state youth who have ran out of run remove themselves from our state. Just gone elsewhere.
The solution to that, I feel like there was some discussion where somebody came up with a solution to that.
It was for under 18, I think. The
Yeah.
compact.
Because, right, Judge Hayes talked about she's involved with the compact, the interstate compact.
And again, yes,
Yes, she
over,
did. She did mention that interstate compact.
right, and the issue there, as she said, is depending on the other state's interpretation, if someone's 19 or 20, they may not view them as a youth. They're supposed to use the definition that is in the state requesting. But again, I think our suggestion would be to have an issue a pickup order or an arrest warrant for a youthful offender over the age of 18. And we understand if that's not possible at this time, but we'll continue to bring it up on the other side, but we just wanted to point that out.
Yeah, I mean, there was, I think there's needed some additional discussion and perhaps testimony about the concept. From what I was gathering yesterday on the concept of the arrest warrant, and this is supposed to be compromised, but I think that it's flagged now definitely as a piece that the Senate can.
Yeah, and we're happy to keep discussing it.
Yeah.
But we did just want to, we appreciate the effort and again, fully respect Judge Zoney being very clear about the family court's ability to issue these. But when you read 50108, it's primarily about ordering the parent, guardian, or custodian to a hearing. And then there's one clause of, sorry, it's mentioned twice, but it's then, if that doesn't work, you can order a pickup for a child.
So let me ask you this, and let me, I guess, ask Eric as well while I'm asking this. If we struck pursuant to subsection 501.8.08C and just had issue an order for an officer to pick up the youth and bring the youth to court, does that get rid of that confusion? If we're looking at 501.1C, I'm supposed to do these other things first. We just stay, in other words, get rid of pursuant to subsection 501.8C of this title. Would that help or that would make a difference?
I don't think so.
Okay.
It doesn't help our sticking point that we don't believe this will be clear to all the judges sitting in family division that they can issue an arrest warrant for youthful offenders. I think it's clear right now that the pickup order, that's clear, and it's referencing back to 50108. It's fine, but the next step is where we're still going to advocate for. But again, we understand if a change can't be made now, but we'll keep talking about it.
Yeah, I think it probably can't be now, but Tom, go ahead.
Given the set of circumstances, it's highly likely that the person's not with the parents.
If it's this subset of over
Right, that
18.
we're talking about,
youthful
and
offenders.
they may flee the state as well, so a pickup order is not gonna work unless if the person is in ECF custody, then the compact will allow them to be picked up. But if they're not considered a youthful offender in the other state, we can't take them on the pickup or without a warrant. And that's definitely not 5108.
Fair enough. So I guess my, just at this point, I think there's a couple really great things in this bill. That one apparently hasn't quite hit the mark. But I think the provision we have on page 5 on the subsection as far as extending the jurisdiction, I've been hearing about that since youthful offenders started, and I think that alone is I think really important step. Wrong about that? I mean, that seems.
No, I think that addresses one of the issues that we raised for you all, and I think it will help in some of the cases. And not to beat a dead horse, but having that coupled with an arrest warrant being clear is, again, for that over 18 population that would potentially age out, that 20-year-old, the 21-year-old that we want to get back in, want to finish the process, the arrest warrant, having that be explicit just helps tie those together. Without that, it's a little bit of half of a sandwich. But again, if you move forward with this.
That's a great.
If you move forward and in your conversations with your counterparts on the Senate, that you're open to this idea being still continued and talked about.
Yeah, oh yeah, no, definitely. I'm flagging some things on various bills that, like for the miscellaneous bill, there were a couple of things that people wanted to put in there. I just felt too late, take it to the Senate and now flag it for the Senate that there are those two things that we didn't quite get to. And then a couple of things that were in the animal cruelty bill that probably need a little bit more work, and I'm gonna flag that for them. And we'll flag this, but I guess the other point is that I think the addition of the criteria and clarification of the criteria are, so there's at least two really good things here. The third needs further work. It's kind of where it seems. I don't know if you agree, but I guess I'm good. Yeah. So,
Agreed. And to just highlight the victim being able to speak at the consideration
the
hearing
victim part is
is
really important too, right?
one
Right.
of the most important aspects here to clean that up. And we greatly appreciate that.
Question that I didn't get to ask you, Kim, the other day that I did ask a couple of other witnesses. And it pertains to page 6, lines 9 through 11, the division C. DCF, Lindy Boudreau speaking for DCF said that they would support removing this as a piece of criteria and or a consideration. And Tucker from GPS just said that the focus should be, he wasn't straight out supporting removing it, but said the focus should be on the youth's behavior in the process so far, recognizing that we are like a ways into the process at this point. I, like Barbara was expressing, I don't like the subjectivity that this introduces, perhaps unnecessarily, and places potential blame on the youth for state or system failure. Am I the only one still in committee right now? Am I like the only one who's still here? Okay.
I do.
So what would your department think of removing that? And what would your department think of removing that?
Well, I wouldn't be able to speak for the whole department right in this moment. I don't think it would. If you removed it because you are concerned that would be a weight on the scale against, I can understand that. I think almost implicit in B of whether the use amenable to treatment or rehabilitation, you're going to be talking about what treatment or rehabilitation, which ties to what service is available. So we're going to be discussing like what can we do if the argument on either side is keep them in youthful offender. Okay, what can we do for them? What is available? Like we do need to talk about what's available.
Right. And
for
I
that.
think, right. So I think your point is actually makes my point as well, that it would come up, it would have to come up. But with this provision in here, it's placing the blame, it's placing it creates an out that's like, well, here's what this youth needs, but we just don't have it. So.
Well, I definitely, I hear that, and I think it's interesting. I mean, it's also stating the reality that if you're saying, oh, we can treat this person, but we don't have the place to treat them.
Well, and my hope is that the language, I'm sorry, just to complete the thought, because I know where you're going, and I without this language, might the process be, here are the needs, we don't have the services, we need to find someone who does. We need to find a way to get these needs met, rather than here's what this youth needs, we don't have the services, so we should abandon ship.
Yeah, it's already down.
I don't know if that's how removing that would lead to that conversation.
Can I ask a quick question on this? This is a criteria for whether somebody gets put into.
In consideration,
Yes.
yes.
But there was considerable conversation the other day about how both DCF and DPS saying that the focus should be at a revocation hearing, the focus should be on the youth behavior in the process so far. And
not, right, and not be like, oh, we didn't have the money to create the program, so we can't serve this kid in youthful offender. We have to put them in jail, right? Like that's what's the reality.
I think, and I apologize, I think the scenario of how this would be discussed at a revocation hearing is consideration hearing happen, the disposition happen, youth is going to meet with this counselor, is going to do this group, is going to do Z, whatever the third picture is. At revocation, this counselor didn't work, they weren't engaging. Is there another counselor who can do this type of treatment? Or is there a different group if they're not doing well in the group? Like, I can see how that is the conversation. If the youth has blown through all the options, like if DCF has tried everything, I mean, that is where, you know, we had all the services, but the youth has not been successful with all of them. I'm not sure if if removing this would have you look outside of the Department of Children and Families, because as they said, they look at all the, they outsource a lot of this,
but right.
almost all of it, as far as the actual direct services.
And again, like it feels like it could be like, well, we have 3 things we offer, but if kids need something else, our state needs to figure out how to serve our kids. It's not like this is the way we teach English, and if you can't learn that way, you're out. Like we want, right? Like we want people to be successful, and we don't want to give an out to the. Like I just feel like if the path of least resistance will take over, and
I'm not sure removing this gets you to where you want to go, but that's the only question mark.
Yeah, I got it. I think I'm looking for believing strongly as I do that words matter, and you know, we signify things by what we say and don't say, and so I just didn't know if there might be a chance that it could signify that the hope is that, you know, that I really appreciate the comments from DCF that like the focus should be on what the youth, how the youth has or has not been engaging with the process so far, and less so on the services that are or are not available because we have or have not invested in them, you know?
or revamp them in a long time.
Yeah, so I'm just struggling a bit with that. If it remains in, I think at a minimum, it should be, there are continued sufficient services as Judge Davenport suggested, because we've got, will be protected by continuing to treat the youth. The youth continues to be amenable. I would think just for consistency's sake, but.
Right, but it's on that spectrum of
Yeah.
care or not.
Yeah. That's not dropping into the start of a process. Thank you.
So do you be fine with continued?
Yes.
So did you catch it, Eric? So I think, if you could, anything else?
So it's just going to be, there are,
Yeah.
I can I just
Yeah.
speak in,
Yeah.
I don't really want to get into debate, but
No, go.
I just, I just want to bring us back to like what this section is doing, which is it's asking the court to consider things, right? And so I do think it's important that the court is considering the services and the system that this youth is in, and whether it's able to satisfy and sort of achieve what it needs to achieve. But if we're talking about, where we're at as a revocation hearing, and we should be thinking, I really think the court should be considering that when it's making that kind of determination. And I understand the counter argument that has to do with a lack of investment in a system or in services, but the problem is we're trying to determine whether what we have is actually serving youth. And I do want to push back, Barbara, that a revocation of a youthful offender status does not mean the youth goes to jail. It moves it out of the family court, but then it's adjudicated in the criminal division. And there are many ways that resolves.
So I should say it gives them a permanent criminal record. It has ramifications that are big. It could result in jail. But I also was going to say, we just passed in the animal welfare bill, we know that we don't have prevention or education classes yet, and it's been identified as a need. We put in some language that's like, should there be approved programs? So I hate to sort of close the door for what's needed for kids. I mean, if judges are like, we need anger management programs in Spanish for kids or something, or the judge should be able to order that, and we should figure out how to get that.
And maybe there's room because it's a consideration and
Right.
It's one of the elements.
yeah, I think I'm probably trying to solve for something much bigger
Yeah.
than the removal of this language can actually do, but feeling very unable to actually make those bigger changes. There's these attempts at teeny tiny ones.
Okay, so I'm sorry, thank you for that. And we're gonna have you back momentarily on 171, but
So we're gonna get another draft of this.
yeah, he's gonna update the draft with that they're continued. And
I'll email it to me and you, then you got, and then hey, can you, will you be able to email that to the committee if I send it to you in 10 minutes or so?
so it'll be the clean version that has taken out the other stuff,
Yeah.
other stuff. Right.
It'll be clean and it'll change the word insufficient.
Right, continued sufficient, I think, right? Is that right,
Yeah.
supposed to be?
Continues.
Or just.
Or you could say continues to be,
services, or
you could say
continue.
continued sufficient services or continues to be sufficient services. We've done it two different ways up above.
Okay,
Right.
continues to be.
There continues.
Whatever area
continues.
How about mirroring B? There continues to be sufficient services.
Continues to.
There continues to be sufficient services.
Well,
That's some things.
Unless we're
Unless we're assuming that there are already sufficient
Yeah,
services.
it-
then Maybe
it's-
that doesn't make sense.
right.
Yeah.
Well, we're assuming that the youth is already amenable.
Well, they've been on youthful offender. They've been in the
Yeah.
process, right? So
They're
So
amenable,
you're
but
saying,
it doesn't mean that they.
sort of assumes that when it was ordered, there was,
We're gonna get cleaned up.
yeah,
So you take it.
which maybe satisfies a bit of your concern.
Okay, all right, we're gonna keep plugging away. All right, so we're gonna go to 171. Or did you decide on this language?
I think are you good with B? Are you good with the B language?
Have a good weekend, guys.
The continues to be.
Yeah, I guess. I'm gonna send it to Nate, send it to you guys. And I mean. I can see next week.
Excellent there.
I
Excellent.
mean.
He goes, Eric's out.
Yeah, that's it.
No. Feel like it. Yeah. Great.
having for a suggestion.
Well, I know, like it'd be great to have.
Certainly hope so.
Thank you. All right, over to Michelle. And there's one change from the version that we went over the other day.
So good afternoon. For the record, Michelle Childs, Office of Legislative Counsel, and the chair is correct. There's just one change from the last time you reviewed this, and that is a new subsection A. And so Representative Oliver had suggested some intent language in there. And so you'll see, starting on line 8, the General Assembly finds it's in the best interest of victims and law enforcement officers to efficiently and thoroughly conduct independent investigations of any officer-involved shooting in Vermont. It's the intent of the General Assembly to facilitate cooperation amongst the entities responsible for investigating an OIS. So there's a well-understood protocol for addressing them that instills public trust in such investigations and resolves investigations in a timely manner to provide certainty to all parties involved.
Are people good with that?
Love
Then do- Good. So we hadn't, we can have Todd Delos tell us whether he's fine with that. All right, could you want to identify yourself on the record and say
Identify
you're fine with that?
For the record, Todd Davis from the Attorney General's office, we're comfortable with that language.
Okay.
Thank you.
And Kim, if you could join us because you haven't had any chance to weigh in on this.
Be real short.
That's great. We love that. And just so everybody knows, we did have Tucker Jones in. I asked him to specifically send written testimony on what he thinks of the bill. He did. It's online. We can count that as witness testimony because I had a conversation and he just was not going to be able to make it when we had taken it out. So, and just that, all right, you go ahead and then I'm going to actually read his response into the record. So it's, but go ahead. Nice to see you.
Good to see you again. Kim McManus, Department of State's Attorneys and Sheriffs. I had all sorts of very smart thoughts for you on the original as introduced bill, but we are well past that, so I'm gonna save those for the sake of time. We support this amendment to create this protocol. We greatly appreciate the addition of that language in subsection A to highlight the issue, which was the timeliness. And with that addition, all my other remarks don't need to be said. We will be happy to be part of this group and present you a report in December.
Okay. So here is the email. Thank you very much, Kim. Here's the email that I got from Tucker Jones as his written testimony. He says, and it's online, it's on our website. Regarding H-171, the Department of Public Safety believes the primary policy interest at play is the timeliness of criminal charging decisions involving officer-involved shootings. To that end, the latest draft, he was referring to draft 1.1, but it's the same exact language. Includes a provision to evaluate the process of investigation and prosecutorial review of officer-involved shootings to ensure timely criminal charging determinations and identify and address existing barriers to timely criminal charging determinations. That's the language. He says, from the department's perspective, the timeliness of these investigations is the main issue that can address not just fairness to officers, but also the prolonged uncertainty for the families of the person who may have been injured or killed, as well as the general public confidence and perceived legitimacy of oversight in light of the fact that these cases involve the government investigating the conduct of government employees. If you need further, anything further on this, please let me know. And I think that kind of hits that point. And there were no airplane metaphors involved. It was just like it was metaphor free. So maybe we should always invite Tucker to provide written. I'm just kidding, Tucker. We like the metaphors. So there's that. Any other questions or concerns with respect to H-171?
He sent that where?
It was an email. It would be yesterday's. It's on Thursday under Tucker Jones on the website.
Thank you.
Yeah, no, just real quick, just want to thank all the interested parties for your concern and you know, in listening to, you know, the witnesses we had and you know, and what they go through. And with that being said, I'd like to make a motion to accept draft 2.1 of H-171.
So I assume that motion is to approve the amendment draft 2.1 H-171.
Exactly.
Second. There's a second. This is just a straw poll, and then we'll have a second vote. All those in favor, please raise your hand or say aye. Aye. Coach?
Aye.
Okay, perfect. And the next motion that I take is that we report H-171 favorable with the amendment.
And again, I will make a motion to accept draft 2.1 of H-171 with amendment.
Second. Any discussion? I guess you already discussed it. Thank you. Anything more? Anybody? So.
Thank you. It's much appreciated.
Yes, thank you.
It definitely is in the industry. I've heard.
Yeah.
A little bit.
Moving it along slowly but surely. everything seems to move here. Clerk call.
Arsenal,
Yes.
Dola,
Yes.
Yes.
both sides, yeah. Harvey,
Yes.
Malay,
She left.
She had to.
Oliver,
Yes.
Rachel,
Yes. Okay.
Christie,
Yes.
Burdick,
Yes.
Malone.
Yes. And Vice Chair Burdick has agreed to, in fact, wants to be the one reporting this, not just agrees yet.
Thank you, everyone.
So we're gonna move to H 410. I see the light.
Excuse me, Mr. Chair.
Yes, sir.
Did we vote on the one before? The
No,
useful
we're
offender?
having we have one change coming, Coach. One final, pretty, small word change, but important word change. It's still coming, and Eric, as soon as he gets it, is gonna email the clean version to Nate. And then we'll distribute that and we'll vote on that.
Oh, okay. Okay.
The next one is that we're looking at H 410. Are those new glasses too?
Have, you know,
It's just that I noticed, yeah.
you gotta have like 8 pairs,
Okay.
different places, so that you can remember where they are. Otherwise, you're gonna have to start wearing the granny necklace with the glasses.
You refuse to do that?
Not yet.
All right, H 410, if you could tell us where we are.
Yeah.
Really quickly, my understanding is that this is in part from the review that happened in corrections, actually like before break. if I'm
Right.
That they raised this kind of issue and this language addresses.
Right, I will,
Go ahead.
so for the record, Michelle Childs, Office of Legislative Counsel, I'm looking at draft 4.2 of committee strike all amendment to H 410. I will start out by saying that I appeared before House Corrections yesterday. I walked through this language as it appears now with them. They were supportive of this language and wanted me to convey that to everybody. So the change really is in the definition for recidivism. And I wasn't in the hearing that I think they had initially raised some issues. But it was about how do you manage the clock when you're trying to calculate recidivism. So you remember that we're in this bill, what you're doing is you're really simplifying the definition and calculation for recidivism because you have a really super complex definition currently that's in Title 28 that you're repealing in this proposal. And so in your new chapter in Title 13, you're creating a new definition, and it's kind of just a more plain language understanding for what folks think of recidivism, which is that you're convicted of one crime and then you are later convicted of another crime, right? But then you got to figure out where are those points that you're doing the calculation because they're doing it, you're asking for annual reports, you're asking for like certain types of calculations. And so this hasn't changed from the previous version. The date of the recidivism event is the date of arraignment for the subsequent offense, right? Because when they're looking at the records, the offenses are all kinds of different dates, right? But they can clearly look from the records and see the arraignment date in the files, right? And have that data. And then what's new is the highlighted language starting on line 14. The clock for calculating recidivism shall begin on the date an individual is either released from incarceration or the date when an individual is sentenced to a non-custodial sentence. Right. So in terms of that, that first sentence, right, or that first conviction, if they're sentenced to any type of incarcerative sentence, then the date that they are released starts the clock. So if you're doing a 3-year look back or a 5-year look back or something like that, that's the date you use. However, if it's they receive probation or something like that, and it's not incarcerative, then that date of sentencing is the date that you use to do the calculation. And also, you might recall that in the definition, it previously had something that said that recidivism shall be calculated with a 3- and a 5-year look back. And I've moved that down to the recidivism annual report, which is on page 2, because that's really kind of what it's focused on. And that's just with the annual report, but we kind of want to leave the the general definition of recidivism a little broader, right? Because the idea is that you're creating this new chapter and you're going to be adding things and doing different things. And that for the purposes of these annual reports, it's a 3 and a 5 year snapshot. But you don't want to put that 3 and 5 year up in the definition section.
Tom,
We probably discussed this. I'm just curious. We're not concerned about reoffending while they're serving sentence. Because we're looking at frequency, right?
I thought the same thing, and then it's like that, I mean, we could somehow have put it in here, but it just like really overcomplicates. I know that does happen
A lot.
but
And on the street. And it's one of the most common things. That's why we have people with 5 dockets.
well, what do you mean by on the street? That's that they're on probation, so they're.
Yeah, but they don't get street, I would be on probation or parole and reoffend.
Yeah, that's
I will capture it.
Okay.
Yeah, that's covered.
Yeah.
Those instances where they're incarcerated and then they recently commit something while incarcerated, that he might not be, well,
That does-
I mean, yeah, it does have, and we can capture that separately if we want a report on that, we can specify that.
Okay.
But it kind of just,
That's fine.
so I did think, I at least was thinking a little bit about that and thought,
That's a little bit, hey.
was it Karen and then Ian?
I agree. I remember us having a,
About that, Martin?
yeah,
It's, yes, I haven't, yes, we have talked about it, but I think this is to simplify it somewhat. And it can
Right.
become.
But-
No, go ahead, Coach.
But I thought that, with the work that we have CRG do anyways, they can disaggregate the data, as we specify. So, that to Tom's point, that's where we can pick it up, I think.
Yeah, I can actually, when CRG is working on this report, it's like, can you have like the subset in the report of people who may have recidivated while they were incarcerated?
And the same,
additional
and the
data.
same thing with what Judge Hardy and Judge Hayes were talking about in the earlier bill with the youthful offender. That's the data there just says it's a really strong functioning program. So data is strong on recidivism in both situations.
Karen and then Ian.
how's that?
Ian.
Oh. I was hoping for more time to think.
Well, we don't,
So-
that's the last thing we need.
That's, yeah. So 2 things. One, I actually would say that people who commit crimes while they are still incarcerated are still in a time when we're not considering them finished with their current sentence. That's not recidivism because they have not stopped, like they have not sort of been convicted and so that's a different question.
And it's a question we can ask.
Yeah, and the question we asked, but if we're trying to define.
That would depend on the definition.
What's that?
Well, I mean, if they're serving a sentence, that would depend on their definition.
Well,
Reoffending is reoffending.
well, I think if we're talking about people, and we don't need to get down this road too far. Just like if we're talking about people who are incarcerated, they're going through programming, they're doing these things, they are basically in their carcerative sentence, and then they commit another crime. I would argue that's not recidivism because they haven't completed their initial. So they haven't done it once and then offended again. And that's like our question that we're looking for.
So a week before they're done and they reoffend, that's, you know what I mean?
But yeah,
We're thinking.
actually the one I'm more curious about is, so I don't remember if we talked about this, but with presumptive parole, what we are saying here is that when someone is on a carcerative sentence and the moment DOC puts them on parole, that it's from that date that we're going to run it from. So they're on parole. They're out.
Right.
So that's what we're good with.
Yeah, well, yeah, they're released from incarceration. Incarceration means they're behind the bar.
Yeah.
I don't think there's another way to interpret that.
Yeah, no, and that we're good with that. Yeah. Okay.
Clarity is key.
Here.
I was just gonna say, I appreciate that point, and for me, it is the public safety piece, not that we shouldn't be concerned about other things that are happening side, the incarceration, but I feel like we're also trying to look at it at the public safety and the community piece of it. And so that's why I feel comfortable with it when somebody's out in the community, if they commit another crime, that's
Yeah.
of extra concern.
Totally.
It definitely is. See if we're doing.
So are we ready to, any questions on this, or are we ready to vote this one? That's what people. Oh, I see that. We're just listening to Angela.
I'm gonna start locking y'all in.
That's a good idea.
We're so close. So can I ask the folks who are going to be reporting a bill to make sure you're sending the correct version to the clerk's office and Nigel, and you have the vote, and you say the right thing, that I think all of these are favorable with amendment. Are they not different? Right. Well, no, there's a committee bill. Maybe those are a little different. You tell them it's committee.
Mine's gone.
And if you could copy me too, but okay.
Done.
I tried.
Tom, that's gonna count for my own.
Because I'm gonna confirm with Nigel
my own weight.
You're
saying then that's recidivism. So.
All right. You get back to.
Right?
I think so. Do we know where Angela went?
I know, I'm done.
I did not see her out there.
Well,
I messaged her.
You gotta draw the line somewhere.
I just like.
How about this?
Coach, is Angela with you?
Thank you for your good counsel. We're all stuck here until irrigating. We have one separate. Bill for
I just forwarded it to everyone.
All right, we got
on your
it.
emails is the newest version of Eric's bill. It's
It
there. If people want the school copies, I can make them. But
Does
it's-
anybody want a hard copy of
No.
the?
No, I'm good.
Save the trail.
Tom, she just went by.
We've killed so many trees
So we're
today.
ready for two votes.
Yes.
Just need our last person.
Yeah, I can see her through the door.
Really?
Just saw her.
Go get her. Nate, go find it.
Yeah, she went by in the
I
kayak.
think I took that job out of it.
I will take a motion. This will be a straw poll.
Oh, there she is.
That we approve draft number 4.2, the amendment draft number 4.2 to H410.
So moved?
Second, anybody?
Yes.
Anyone?
Sure.
All those in favor of approving the draft number 4.2 to H410, please raise your hand. Anybody opposed? Did you raise your hand, Kenny?
Yes.
No, because I'm looking for 4.2.
Oh, you should.
No, I'm good, I'm sure.
On that part, I mean, the more important vote is right
Right.
now, which is, I will take a motion that we report H410 favorable with amendment.
Second.
Who was the first?
Me.
All
Yes.
right, Karen?
Second.
Second. Okay.
Double second.
That's just how my days
You
go.
need that, you need a moment,
Second.
Ken, for. What? Did you find what you needed?
No,
You could.
oh,
This is-
I'll take that, thank you. Arsenal,
Yes.
Dolan,
Yes.
No.
Yes.
Bosley, yeah. Harvey,
Yes.
what? Oliver,
Yeah.
Rachelson,
Yes.
Christie,
Yes.
Burdick,
Yes.
Vaughn.
Yes. And Karen is gonna be doing that one. So you have on your email, draft number 3.1 to H642. The one thing that it does from what we last saw was it adds the language on page.
It's in our email.
It's in your email from May.
Yeah, we just
I
got
sent
that.
it, it should.
Yeah, I got it.
Last night,
Okay,
I-
it's on the
not
top of
posted it yet.
page, it's on the top of page 3, where it says there continues to be sufficient services. Okay?
I think the page number changed so much.
I got rid of the first two pages.
Oh, because we told.
Is he in the show?
Yeah. Hey, we'll see you, Michelle. I will take a motion that we approve amendment draft 3.1 to H642. This is a straw poll.
So moved.
I had 3 people who said, so we'll give this one to Coach.
Oh, coach.
And it was, and Tom was the second. And this is straw poll. Is it one of the straw poll? All right, all those in favor, please raise your hand
Aye.
or say aye. All right, those opposed, that was unanimous. And now I will take a motion that we report H410, our last H bill of the.
Wait, H410.
H642. I was just testing you. Kenny. I was just testing you, Kenny. H642, favorable with amendments. I'll take that motion.
So moved.
For a second.
Second.
And Coach is a second. Any discussion?
Yes, will be voting in favor of this. I don't think that we have gotten it all the way there. So I look forward to seeing what our colleagues in the Senate will do, and we'll be excited to see what it looks like when it comes back to us.
And I said, I guess earlier that there's a couple, 3 really important things that the bill does, even though there's one more thing that we still need to try to get right.
Yes. And I don't mean that to be like overly critical or
Yeah,
anything.
no, it's good to have that on record. So. Angela.
Yeah, I'll say that I will reluctantly probably vote in favor. Though I don't favor the bill. I don't favor, I really appreciate the work that's done through this bill for victims in youthful proceedings. But I continue to really struggle with our non-data driven decision-making when it comes to juvenile justice. I struggle with the lack of data, the reliance on anecdote and potentially now outdated anecdotal data, which is somehow worse than regular anecdotal data. And it just feels, the testimony we heard from Judge Davenport was really compelling that this, and that was based on actual numbers and data, that this is a very youthful offenders, a very successful program when measured by recidivism rates. So with just the more we kind of like nibble at it and poke, and it doesn't sit right with me. I'm worried about poking the wrong thing, and just like, I don't know, it just feels like we are inching further away from a really big, important decision that was made several years ago. Again, based on brain science and data, and those facts haven't changed. And I know that this isn't attacking that so much, but it's tangential, and it just seems like, yeah, I find it concerning, the approach in general. So for the victim offender, the victim work that this bill does, I will support it.
So if I may,
Yeah, please.
I understand where Representative Arsenal's coming from, and I think that what was being shared from Judge Davenport and then later Judge Harvey is the transition of the 2 of them on the council. And they're 2 of our most reliable monitors of our work. And I think a way to better track ours is to continue to ask the questions, the data questions that we're able to through our research arm, being CRG specifically on this project, because now they've developed metrics to take those deeper dives so that we can get even more clarity that's data driven. So I'm hoping that we continue to go in that direction, because that'll make us all hopefully be able to see the things we need to see.
Yeah, and so just, I guess, a little comment to what Angela's concerns are, and I understand that, but this is a successful program. I want to continue to be successful. I want there to be less opportunity for people to be negative towards it. And I think that one of those is particularly when people age out and don't seem to be doing what they should be doing towards the end. And I think that's really one of the biggest things. And that kind of goes with the no-show, which apparently we haven't quite handled. And it's always good to make sure if judges are using all sorts of different standards to look at a revocation motion, it's probably good for us to give them the standards, and it makes sense that they look at the same thing. So I don't feel it's like inching. I don't think it does any damage to the program. I think we need to focus on making it better, like the issues that you're talking about, is making sure that the rehabilitation services are available, that we're doing those kind of things. So that's kind of the way I've looked at this. I'm not trying to cut into this program at all. I'm trying to take away some of the kind of the negative views towards it by thought. So that's kind of where I'm coming from on this. Anything else? Go ahead.
Arsenal.
No. I said go ahead, Barbara. I'll say.
I thought I would share my 48 questions and answers from yesterday. So, okay, it's a baby. Okay, so I feel like there's been some good harm reduction done on this bill, and hearing Angela talk made me think, oh my gosh, do I want to send an 11-0 message that this is like all peachy keen and fine?
You're not going to.
10-0.
Oh, right. Anyway, so I very much share, like, I don't know who's reporting it, but I just think it's really important to talk about how well the program is working.
Yeah.
And I have to dig deep inside and see how I'm going to vote.
Yeah, that's fine. No, I think vote where you want to vote. That's definitely fine. The clerk may call.
Arsenal,
Yes.
Dolan,
Yes.
Goodnow,
Yes.
Osai, yes, Harvey,
Yes.
Malay, Oliver.
Yep.
Rachelson,
Yes.
too late now. Christie,
Yes.
Burdick,
Yes.
Malone.
Yes. All right, so Ian's gonna report that. He also heard me say earlier, please, get the right report to Nigel as soon as possible with the vote.
Right, as we speak.
And I'll just confirm with Nigel that we have everything right. So thank you, everybody, for getting through today, getting through crossover. We did a lot of really good work, I think, this year. My build tracker has many places where it looks like you got through almost all the what seemed to be priorities at the beginning of the year. So next week will be interesting. We're going to be doing work on a couple bills that are in money committees that are not our bills. There's one from Human Services, H657, that has a little piece in it. It has immunity provision. I think they were going to vote it out today, but we can look at it. I've looked at it and doubt that we're going to have an amendment on that, or would have an amendment. But then there's the landlord tenant one, and that one we'll be working on next Tuesday. After Tuesday, I'm not sure what we'll be working on yet. So we'll see. We're adjourned until Tuesday at 1 o'clock.